Okay, welcome everyone. Welcome to the Housing Court training. Today we are going to be having a training on ADA accommodations and when can a landlord sue you for rent, particularly with the emphasis on when it can happen in civil court and also in housing court. So today we have our presenter, Miss Mary McCoon. Miss Mary McCoon has worked as a public interest attorney for over 25 years. She is currently a senior staff attorney in the Economics Justice Unit at Manhattan Legal Service. Over her lengthy career, Ms. McCoon has represented low-income people in many practice areas, including housing law, family law, benefits law, as well as consumer law, and has litigated social justice issues in federal, state, and city courts on behalf of her clients. She is also the co-chair of Consumer Rent Arrears Work Group, which brings housing and consumer advocates together to address court cases involving rent arrears that are brought in courts other than housing court and related issues. So she's very well-rounded, which is why we're super excited to have her today. So now I'm going to turn over to Miss Mary McCoon, and thank you again for doing this presentation.
Well, thank you for the opportunity. It's very difficult to find someone that can give you advice on these sorts of issues. So I'm really happy to have this forum to talk to people about it. The training, I noticed I have the wrong date on it. It is February 23rd, not February 24th. I was getting ahead of myself. I guess I want it to be Friday already. But it's going to be in two sections. The first is about getting accommodations if you need them in courts in New York. And then the second half is going to be more about being sued for rent arrears in various courts and how to try to avoid it, and how other courts are different than housing court in terms of tenants' rights when they're sued for rent arrears. If you guys if you could hold your questions till the end of this section, that would be great. If you were like me and you were worried you will forget your question before that moment comes, feel free to type it in the chat, and someone else is going to be monitoring it because I'm not good at presenting and monitoring the chat at the same time. So with that, I think we can get started. Okay, except that it's not letting me switch slides. There we go. I think I just wasn't pressing hard enough. So the first section is going to be about ADA accommodations in New York courts. I know it says civil court, but it's not. It's focused on that, but it applies to all the courts. And this is the shorter section, so it's probably going to be like 15 minutes maybe. All right, so when do you have a right to an accommodation? If you have a physical or mental disability that substantially limits a major life activity, you can ask for an accommodation to allow you to participate fully in a court proceeding. So some examples of, I know it says impairment because that's the term the law uses. I don't like that term. I know a lot of people don't, but that's why it says impairment on the slide. So an example can be asthma. That can affect your breathing. That's certainly a major life activity. Chronic fatigue can affect your ability to walk. Depression can impact your ability to feed and care for yourself. Long COVID, similar to chronic fatigue. Autism, you may have difficulty communicating or functioning in a crowded, noisy space. Arthritis, deafness, blindness. I give a lot of examples because a lot of times the courts, particularly when they think disability, they think person in a wheelchair. They are not super sensitive to invisible disabilities, and it can be challenging to get them even when you're legally entitled to them. Another confusion for people is that the accommodation you request must be related to your disability and be reasonable. And what they mean by reasonable is usually it can't be extraordinarily difficult to provide or extraordinarily expensive. So think about what you don't, think outside the box. If you have a disability and it will be difficult for you to function in a courtroom or to get to court or however it's impacting your ability to participate in the court process, think about it ahead of time and what would make it easier for you to engage fully in the court system. So how do you request an accommodation? So for civil and housing court, there's an online portal that you can use, and I have the link here. If you don't have access to that portal, you can also send an email to the chief clerk. And I have her contact information there. And she prefers that you put ADA accommodation request in the subject line to flag it for her. You can also call the ADA coordinator for the court. And I have a link to for contact information for each borough. This is for New York City courts. So the state courts also have ADA accommodators. So ADA coordinators. So you would just have to contact the court and find out who the ADA coordinator is. That information is available on the court website, but you can also just call up the courthouse and ask. And if you aren't able to ask ahead of time for whatever reason, you can also ask the day of the court date if you need an accommodation that they can provide. Be prepared for the fact that even though the contact information I've given you is posted publicly online, sometimes I call the people and they have no idea that they are responsible for accommodations and don't know how to process them. So you need to sort of gear yourself up to be a strong advocate or recruit someone who can advocate for you, because unfortunately, although this should just be a very simple process, it usually turns out to be quite an ordeal. So what information do you need to tell them when you make your initial request? Obviously your name, a brief description of your disability, the accommodations you want, what will help you be able to participate in the court date, the name of your court case and the index number, the number assigned to it, if you know, and the name of the judge, if you know ahead of time. In housing court, your case can be assigned to a part, and that judge will be the same judge for a quite lengthy period of time. In civil court, however, the judges rotate frequently in and out of the civil court part that deals with rent arrears cases. So you won't always know ahead of time who your judge is. And they'll need to also know the dates that you'll be in court and your contact information. So when should you request the accommodation? As soon as possible. The court is insanely slow in processing these requests. They said that this new portal would facilitate and streamline things. As far as I can tell, it has not. So it's as soon as you know you have a court date and you're going to have to go to court and you know you'll need an accommodation for that court date, contact the court. Don't wait till the day before. It's never going to get processed. I've had people ask for accommodations a month ahead of time and they haven't been processed. So as soon as you possibly can, just ask. If you don't hear back from the court, follow up. So follow up 2 weeks before, a week before. Don't wait till the day before, because by then it will already be too late. If you happen to have been one of the lucky few who had your accommodation approved and you're in court that day and you get your accommodation, but you know you're going to have to come back to court at a later date, maybe the case is being adjourned, ask if the judge can approve your accommodation for the next court date as well. Because it's not like a one-time thing that you show you need an accommodation and then all you have to do is say, it was approved before, do it. Like every time you deal with a new judge, every time you deal with a new court date, you have to make a new request, which is very frustrating for obvious reasons. So what kind of accommodations can you ask for? So a common one is maybe you'll be allowed to use an accessible entrance or an elevator not normally open to the public, assistive listening devices, screen readers, preferred seating, having your case called out of order. Maybe you need your case taken right away. You can't wait 2 hours because of your condition. Your court date may be scheduled for the afternoon or the morning. If you have a medical condition that's impacted, like I have a client who takes a medication that really wipes him out in the mornings, but in the afternoons he's okay. So in most courts, there are afternoon court dates that are allowed. If you can't go to court in person for whatever reason, you can ask for a virtual court date, which would be participating by phone or using a computer. You can also, if you can't get to court to file paperwork, you can ask for an accommodation to be able to file electronically or by mail or by fax. If that's not otherwise available in the court you have to appear in, you can ask for a support person to be able to go with you. I mean, you can always bring someone with you to court, but often if you go to talk to the judge, they just want you to be there. So you can arrange ahead of time to smooth that out and make sure that they can be with you when you have to, if you do have to talk to the judge. And any other reasonable accommodation that will allow you to participate in the court date. For example, if you're diabetic, generally there's no eating or drinking in the courtroom, but if your blood sugar starts, going south, you can ask for an accommodation that you can eat in the courtroom or drink something if you need to. So what if, this is unfortunately all too common, what if your request is not granted in time? Contact the court clerk's office to explain that you can't go, that you asked for an accommodation and you're not physically able to go to court. Do that preferably in writing by email or letter, and ask for an adjournment for that request to be processed. The procedure can vary from court to court, so I usually recommend calling the court clerk and asking them what you should do. If your disability doesn't prevent you from going to court, but it does prevent you from participating fully, you can go to court and ask for that accommodation on the court date. If you can't get a hold of the court clerk's office, you can't go in person, and there is someone else you can ask to go for you, you can write a notarized letter giving them permission to ask for an adjournment on your behalf to get more time for your request to be processed. I know I had one more thing I wanted to say, but it's already slipped my mind. And you can also, well, skip that. Let's keep going. If your request is denied, you have a right to appeal that request. It's called a reconsideration. There's a form online that you can use, or you can just send a letter, and the letter has to have what you would expect: your contact information, your name, the court involved, the accommodation you asked for, why the decision denying it was wrong, what resolution you want, and then attach a copy of the denial. You can also attach additional documents at this stage if you didn't have them available at the time you originally made the request. So say that you told them you had an accommodation, but you didn't perhaps have a letter from your doctor, and the denial said you hadn't established that you really needed the accommodation that you requested, that they didn't understand how your condition required that accommodation. So you could go to a doctor and ask them for a letter to connect those dots and submit that. And then you have to mail or email it to the address on the slide. And you have 10 days to do it, but you can ask for an extension if you need it. So especially if you're trying to get medical documentation and you can't right away, then just write to that address and say you need an extension. The other thing I encourage people to consider, because this is a widespread problem that impacts many people, and the burden is put on the disabled person needing the accommodation to fight an entire court system to get what they should get automatically, which is overwhelming. You might want to recruit some help. So you can contact elected officials, advocacy organizations, including legal services organizations for help. And you can also consider seeing if media will take up the story. A lot of the online cable news networks have tip lines and so on, and local papers often like to take up these issues as well. All right, so that's all I got on the accommodations. Do people have any questions about that?
Okay, so I'm gonna go through it. I haven't seen any questions so far, but I guess we can give people a 1 minute to put in any questions.
I'll tell you one, I'll do a little time filler while people are having a moment to think about questions. Is one of my colleagues who works at Legal Aid has requested information from the court system through the Freedom of Information Law to find out how they're processing these complaints. And they were keeping statistics on how many complaints they processed, but not on whether they were denied or granted. So there's some problems with that. There's not a lot of accountability. The other thing that I didn't mention that maybe is good to mention is I think I said the clerks, when you call them, don't always know who to send you to. The same is true of the judges. Like the judges will send you to the clerk's office saying it's on the clerk's office to fix this. And then the clerk's office will send you to the judge. For some things that are more like how to get in and out of the courthouse, the clerk's office is supposed to deal with that. But for things that happen more in the courtroom, like if you need a screen reader, which is technology they bring in that will, it's kind of like closed captioning sort of tech, then the judge can grant that in the courtroom. So a lot of times, unfortunately, you end up being the one having to educate them. Instead of them telling you what the process is, you have to sort of tell them. So it can be very frustrating, as I said, but just if you stick with it, you usually can get them. And people are nice. It's not like they don't want to help. They just don't understand. So it's not like they're like, oh, I don't care about you. You're an awful person. It's more like, I have no idea how to get this done. I see some
Okay.
raised hands.
Yeah. So if you have questions, please post them in the chat. Unless you're unable to. So just gonna give them a minute. Okay, I'm going to unmute Francesca, just if that's okay?
Sure.
Okay.
Okay, so Francesca,
I
what's your,
appreciate it.
or
Thank
Francisco,
yes,
I guess.
I appreciate
Yes,
it.
sir.
Thank you, because I'm not able to put anything in the chat. I'm just asking a question for someone. I'm not sure if this question is appropriate, is the right question I'm going to ask you. So, a person is renting, and during the COVID, there was those moratorium. Am I saying the right word?
Moratorium, yes.
Yeah, for the rents and stuff. So the rent that the person was supposed to be paying, they kept it. They had it in the bank. And then as anything else, they went to the landlord to pay for the rent after everything,
I'm
calmed down
gonna
everything.
interrupt you right now because we are going to be talking more about rent arrears in the next
Mhm.
section, but this is about asking for accommodations if you're going to court. So does this question, is it related to the accommodations part, or is it more a general question about rent arrears cases in court?
Um, I think it's more accommodation because the person went to court already, and the landlord does not want to accept the rent anymore.
Okay, so that's not an accommodation, like that, whether the landlord takes the rent or not, or
Mhm.
has to take the rent or not, that's a legal question. So
Mhm.
it's whether someone is disabled or not, it's the same. It's not like the court can do something, particular for you because you're disabled. That would be different.
Okay.
Unless it's, there are some discrimination issues that might come up, like, so it might come into play with that, but that's not really, I think,
Mhm.
what this particular section is about. So maybe hold that thought for later.
Okay, and we did get some questions. Questions about stipulations and rent arrears will be addressed in the second part of, so those questions we're gonna skip for now. But someone has a question of, are there examples of accommodations for invisible disabilities?
So they can be, I can give you some examples. So one is to have a support person, a support animal. If you have one, those could be accommodations where you could bring them with you to court. Another type of accommodation could be, the courtroom can be very loud and noisy. You might be able, and that might trigger some people, or they might have PTSD that's triggered by being in the courtroom. So you could ask to, instead of going to court in person, you could ask to attend the court date virtually. So just call in or use your laptop to participate, so you don't have to be in that kind of environment. It could also be that You could ask for your case to be called earlier if sitting in the courtroom creates anxiety and you have an anxiety disorder. That might be something that would be appropriate. Or to wait in a quiet space, like maybe they can let you sit in a different area where it's less crazy. So those are all kinds of accommodations that you might request for that. If you have back pain and you have to sit on these hard benches, that's difficult. So maybe you can't sit still for a long period of time. So you could give them a cell phone number or something and go out in the hallway and move around as you needed to, and just have them call you when they're ready to hear your case. That's another possible example. Maybe other people have others. If you have other ideas, you can put them in the chat. But those are just some of the things I can think of off the top of my head.
I have another question. So it says, is it possible for the courts to hire a staff member that solely handles ADA accommodations? Is this something that people have advocated for?
Well, yes, people have advocated. And what we have are coordinators, ADA coordinators. Unfortunately, that is usually just one role, and that is a problem because, but it's not just that they don't have one person dedicated to it. It's that the people that would come in contact with someone requesting a disability, the people in the courtroom, the people at the clerk's window when you go to file an answer to a court case, they can't answer the question. So there needs to be training across the board of everyone. Just having one person that people can tell you to call isn't going to be enough, because there's more people that are going to be calling than that one person can handle. There are a lot of people with disabilities. One of the things that's really tragic is during the pandemic, being able to attend virtually without having to ask permission really made court so accessible to a lot of people with disabilities. And now they're sort of just trying to step back from that. They have the technology, it's there, they know it works, they used it for years, at least in civil court. And yet they act like it's inferior. It's an inferior way of doing court cases when it's really superior for people with disabilities. It allows them fuller participation. So no, sadly, there is not really one dedicated person, but we need to change the culture of the court across the board. Just having one person and siloing that person, saying, oh, you're disabled, go to that person, forget all these other people in the courthouse. They don't have to learn anything, even though they're the ones you'll deal with most of the time, isn't going to address the problem. It's really important for us all to advocate as best we can to get better treatment for people with disabilities and a better process in place.
Okay, and one last question. Can visually impaired folks request for all documents to be in Braille?
I know that they do have large letters, large print documents. Those are routinely available for forms that get handed out a lot. In terms of whether specific individual paperwork can be provided in Braille, that would have to be an individual request, because every lawsuit that's filed against someone, will have different facts. So the court can't kind of just have that on hand. But and then but yeah, I mean, in theory, that's an accommodation you can request and it should be granted, but I don't think it's commonly available at this time. But they will
Okay.
read them to people. They will get a reader if you need one for use in the courthouse, but that doesn't help you when you're not in the courthouse.
So that's all the questions we have right now regarding ADA accommodations. So did we want to start on the next section?
Sure. And I'm not sure, but somehow the PowerPoint is getting drawn on. But it's not me. So I'm not sure how that's happening. But just ignore the squiggles or just treat them as illustration. So lawsuits for rent arrears. If a landlord in New York City wants to evict a tenant for non-payment of rent, they have to sue the tenant in housing court. If they're not trying to evict, they just want the money, they can sue tenants in many different courts. Small claims, they can sue for up to $10,000. Civil court, they can sue up to $50,000, or Supreme Court. or they can sue for anything over $50,000. How it's a little hard to sort of game out why landlords choose one court over another, but the courts offer different things and have different processes. So maybe if we look at that, that can give us some idea. So for small claims court, one of the differences between that and housing court is there's no right to counsel. Like in housing court right now, if you're income eligible and you need an attorney, you have a right to get an attorney. It doesn't work perfectly, the system. There aren't enough attorneys right now to accommodate everyone's needs, but in principle, you can get an attorney. Most legal services organizations have housing attorneys that help people in housing court. Almost no one takes small claims cases. And that's partly because small claims court is designed for people to participate without lawyers. So the assumption is that nobody has a lawyer in small claims court. And one of the reasons is that the rules are less informal. So for example, you don't have to worry about the rules of evidence, on the TV shows, and somebody tries to give something in and somebody says objection, hearsay, or irrelevant or whatever. You don't need to worry about that in small claims court. They pretty much take anything you want into evidence. But on the other hand, it's very challenging to get documents from the other side, which is something you can request in housing court, though you don't get it automatically. And sometimes the other side might be the one that has the proof that you need to show you don't owe the rent arrears. Like maybe they have your money orders, you don't have your receipts, but you paid that month. And so if they showed you the money order they received, maybe you could straighten things out. The other thing about small claims is you have a choice between going in front of a judge or going in front of an arbitrator. It can be pretty fast to see an arbitrator, but you can't appeal an arbitration decision except in really, really narrow circumstances. It has to be such a violation of, and so unjust, the decision, that that's really the only way you can appeal it. So you're stuck with that decision if you don't like it. But if you want to go to a trial judge, you can appeal, but you're going to be waiting a really long time to see that judge. At times, the wait has been a year or longer. They started having a mandatory mediation pilot in some boroughs. I'm not sure of the current status, but in that case, before anything happens, the parties have to sit down with a mediator and see if they can work stuff out on their own. The advantages to that is that the parties control the outcome. It's not like some third person, like a judge or an arbitrator, that's just going to decide and cut the baby in half or what have you. But on the other side, there are power imbalances that can make that process not work for people. For example, landlords, if you don't want to get in a huge knockdown, drag out fight with your landlord in small claims court, if you know the landlord has control over whether or not you get the repairs that you need, or you're worried they might evict you. So that can be very difficult to work out. But if that issue isn't present, mediation can be very quick. And I'm a certified mediator. It can let you get to a lot of stuff that's not legal and lets you think outside of the box to get a solution that may not be completely legal. It may be like, we hate each other and we recognize that, but this is how we'll interact going forward by email. I'll only talk to one person in the office. You can work with all that stuff. Now, civil and Supreme Court also have no right to counsel. They are not designed to be user-friendly. They are the opposite. They sort of assume that both sides will have an attorney. There tend to be very few legal services organizations who can take on those cases in civil court and Supreme Court, just really a handful of people across the city, because there just isn't funding for it, to be honest, unfortunately. Parties can automatically request documents and information and from the other side. So that is a plus. You can get a lot of information and proof that you notified them a million times about repair issues and they kept not showing up. But the courts are not necessarily tenant friendly, and many of the judges are less familiar with housing law than judges in housing court would be. And there are fewer supports in place if you don't have an attorney. So what is it? When do landlords file in courts other than housing court, and why? So these are typical scenarios. The tenant moved out before the lease ended. The landlord sued the tenant in housing court, and both sides agreed to sever some of the rent arrears. That means set it aside without resolving it. And the landlord reserved the right to sue the tenant for the rent arrears in another court at a later time. Or it comes up sometimes when the tenant agreed to move out, but the landlord did not agree to waive the rent arrears or release the tenant from the lease in writing. Sometimes there was a verbal agreement and the tenant thought, everything's cool, I move out, I'm done. And then they're sued a few years later for the rent arrears they owed at the time they moved out. Another reason why they file is that sometimes the money the landlord is suing for, it includes things that you can't sue for in housing court, like utility fees, like if your utilities are part of your rent, but a separate fee, repair charges, other types of debt, like late fees is another one that's common. And the other reason is maybe the tenant is still in the apartment, so the landlord could sue in housing court, but the landlord just wants the arrears and doesn't want to evict the tenant. And sometimes they just want to get away from right to counsel, right? It's easier for them if you don't have an attorney. So now I'm going to dive in a little deeper to those different categories. If the tenant moved out before the lease ended, the landlord can sue the tenant for the months left on the lease up until the time the landlord was able to re-rent the apartment, unless the lease said that the tenant could move out early and the tenant complied with any conditions in the lease that they had to be able to do that. The other time, one of the other times is when under certain laws, the tenant is allowed to break the lease without penalties. Those are laws that generally apply to senior citizens moving into senior housing or medical facilities like nursing homes, domestic violence survivors or victims who have to move out because of the domestic violence, veterans who have been put on active duty and have to break their lease for that reason. In general, most tenants have a right to sublet the lease for the months left on it, but they have to meet certain conditions. It's a very challenging process to meet all the conditions, or they can assign the lease. Assigning, when you sublet, it's still your apartment and you're just getting somebody else to pay the rent. Assigning the lease is when you give up your rights completely to the apartment and hand it over, and that person becomes responsible for the rent. It's kind of hard to sublet or assign the lease. The landlord has to agree and consent or not unreasonably deny your request, and that can be hard to accomplish. Then another time they can't sue you for rent left on your lease is if they agreed in writing to release you from the lease. So they can't sue you for moving out if they said in writing, if you move out, I'll waive the rent arrears and I'll waive the rest of the months left on the lease. The other reason when they can't really sue you for rent is if it wasn't really your choice to move out. Like the conditions in the apartment were so bad, you could not live there and the landlord did not or could not fix them. So that can be if there was a fire, for example, or really bad leaks, mold, lead paint, what have you. And just one note is the law changed in June 2019. So for anyone that moved out after that date, the landlord can't sue you for months left on the lease if you broke the lease, unless they can show that they made a good faith effort to re-rent your apartment for those months and were not able to do so. Okay, and another time tenants get sued is when they move out, but they owed rent at the time they moved out. So they can, if you move out, and even if your lease is expired, the landlord can still sue you if you owed rent from before the lease expired and before you moved out. Then if there was no lease in effect at the time the rent arrears came due, the landlord can still sue you. A lot of people think they want to move out and so they don't sign the renewal lease. and they just leave after a few months and they think because there's no lease, they cannot be sued. That is not correct, unfortunately. What happens is they call it a different name. It's use and occupancy. It's money that you owe to the landlord for using and occupying that space when you didn't have a lease. And giving up the apartment generally does not cancel any rent arrears that were owed unless there is a specific agreement stating that in writing. I have so many tenants come to me who moved out in the middle of a housing court case because the landlord wouldn't do repairs, and were told that if they moved out, they wouldn't have to pay the rent arrears. And then they bring me a stipulation that says the landlord, is agreeing for them to move out, but not giving up the rent arrears. So be really careful when you sign things in housing court and make sure you really understand the consequences. So when can a landlord sue a tenant in another court for rent arrears it already sued for in housing court? Like if you were in a non-pay or a holdover and you moved out in the middle of it and there was no final resolution to that case, then the landlord may have the right to sue you in a different court. Because once you move out, they can only sue you in housing court if you are living in the apartment at the time the lawsuit starts. So if you move out, they have to sue you in another court. So one example of language that I see that leads to heartache for many tenants is a stipulation that says that the parties agree to sever some rent arrears or that the landlord reserves its right to sue for some arrears in a plenary proceeding or other forum. So if you see those words like sever, plenary proceeding, other forum, that is a sign that the landlord is giving up on the housing court case, but not giving up on the monies it says that the tenant owes. Sever just means they're setting it aside. That can be for a lot of reasons, and sometimes it's to the tenant's advantage. Sometimes there's a fight over how much money is owed. The tenant says they paid it. The landlord says they didn't. The tenant maybe doesn't have the receipts. So the landlord says, to get this case done, let's just agree to the amount that we know is owed, and we'll worry about the other stuff further down the line. And that may seem like a great deal and less stress, but unfortunately, landlords, unless they say they'll waive that amount and give it up, like you could be seeing them suing you further on down the line. It used to be really uncommon that landlords would bring these cases after housing court. So I know a lot of attorneys and judges would tell tenants like, oh yeah, your income is from public assistance or government benefits, so it's protected from debt collection. They're never going to sue you. Guess what? They will sue you now. It happens all the time. Can't make that assumption. And unfortunately, the judges still think that is the case, housing court judges. So just take that with a grain of salt if anyone tells you that. Another time they can sue you is if the housing court case ended and there's words in the stipulation that say it was discontinued, that means ended without prejudice. What does that mean? Like that means that it's not what you think. It means that they are saying they're reserving their right to sue you again if they want to, that there is not a final agreement on whether this money is owed or not. And to the extent that this stipulation settles some issues, they're not giving up their claims to other money. Like this would be typically if you agree the rent arrears are owed, but then there's other stuff that can't be sued for in housing court that's part of the amount they said you owed, like increases for security deposits, legal fees, late fees, repair charges, the utility kinds of charges, like air conditioner charges, wash it, whatever. So they'll say, okay, we'll resolve the rent arrears, but the other stuff, like if I have to sue you in another court, like I'll do that. So I don't want this agreement to take away my right to do that just because I can't get that money here. So look out for that language. So the tenant is still in the apartment and owes rent arrears. So this is, I kind of touched on this earlier, but this is when they could sue you in housing court, but they don't. Like, what's up with that? So during the pandemic, as I mentioned, and as I know you guys are aware, because you brought up, there was a moratorium in housing court. So landlords weren't suing tenants in housing court, but they still wanted their money. So some of them started filing lawsuits in civil court and Supreme Court. And having tried that, some of them like it better there because no right to counsel. They can sue for everything, rent and all these other fees, late fees, what have you. And a lot of times it's a lot easier for a judge to give the landlord what the landlord wants when they know the person's not going to be evicted, right? So they may be less sympathetic to tenants and less willing to sort of cut them some slack when they look at it more as a debt collection action than as an eviction action. So it's, and also just like I said, a lot of the judges in those cases, in those courts are less familiar with housing law. And because tenants aren't represented, they rely on the landlord attorneys to educate them on the law, and the landlord attorneys are going to say what's to their client's advantage. They're not going to talk about the tenant's rights. And it is challenging for tenants to be able to communicate to their rights to a judge, even if they know their rights as a tenant, because these judges are not used to dealing with people that are unrepresented. They use a lot of legal jargon. They get impatient, not fun generally. So the defenses to rent arrears cases that are related to the housing issues are usually constructive eviction. That's when the tenant has to leave the apartment because it was uninhabitable and the landlord wouldn't make the repairs. I mentioned that earlier. Could be a rent overcharge if the person is rent stabilized. Maybe the landlord was charging more than they were legally entitled to. Breach of warranty of habitability. Maybe the tenant doesn't owe the rent charged because the conditions in the apartment were so bad that they shouldn't have had to pay the full rent. In the case of broken leases, that the landlord didn't make a good faith effort to re-rent the apartment. So what does that look like? Maybe that's you were paying $1,000 rent and it was a preferential rent, and then you leave and the landlord lists the apartment on the internet or with a broker and is asking for $3,000 and no one will take it. So that's not really good faith, right? Because if you could only get $1,000 the last time you rented it, why is someone going to suddenly pay $3,000 like in the middle of a pandemic when people are leaving the city? That's an example. And of course, it could be that you don't owe the rent. Another issue, this may be in a later slide, I'm not sure, but statute of limitations can come into play. The statute of limitations is how long you have to sue someone for a violation of whatever. Like in rent arrears cases, it's usually the lease, that the lease was broken either because you didn't pay the rent owed under the lease or you broke the lease to move out. So for rent arrears cases, they have 6 years to sue you from the time the rent was due. So that's a really long time. But if they wait too long, if they wait 7 years to sue you, that would also be a defense. And I also have here, it is important to consult with an attorney to identify all of your possible defenses. There are a lot of defenses available in other courts that aren't commonly used in housing court. And they depend a lot on the facts of the case. So I didn't list a lot of them, but that's why you should talk to a lawyer if you can. How to avoid being sued for rent arrears. Like once you move out or after a housing court case ends, even if you're still in the apartment, if it's a broken lease case, check to see if you have the legal right before you move out, like see if you can move out and get approval of that breaking the lease because you're a domestic violence survivor, a senior citizen, a veteran, or I guess it's not really a veteran, it's someone on active duty, someone in the military on active duty. Or maybe your lease says you can move out early, like read your lease. Look and see if it says like, if you give 2 months notice and pay $200, we'll let you out of like your lease, no matter how many months you have left on it. Then you can move out if you do those things. If you're a senior citizen or a domestic violence victim, there are certain notices that you have to give and in order to be able to take advantage of the law that allows you to break your lease without having to pay. the balance of the lease. So talk to an attorney about that or an advocacy group. Move out agreements. If you are in court and you agree to move out, make sure that the stipulation where you agree to move out resolves the rent arrears. So if the landlord says they'll waive the rent arrears and release you from your lease, that means let you out of your lease so you don't have to pay the rest of the lease. Make sure that is in writing. If you're in court or if you're doing this informally out of court, has to be in writing. Pretty much every lease says that no oral agreements can change the lease, that all changes to the lease have to be in writing. So if your lease says, like, if you move out, they have a right to go after you for the rest of the lease, you need to get in writing that they're giving up that money. And if you have been sued in housing court and you're going to move out, you know, you're not going to pay the rent, you're just getting the hell out of there. That can, if there are loose ends, like they could come back, right? They can sue you later. So if you are able to negotiate something where you can resolve everything, if you don't want to be sued a second time in another court where it's harder to get an attorney, deal with the rent arrears. It may be very appealing to just say, like, we fought and we fought and we fought and we're down to $500 that we don't agree over. Let's just set that aside. Like, sometimes they will literally sue you for $500 in another court. And that can be not so much fun. I already mentioned the statute of limitations. If you move out or are evicted, keep your records for 6 years. I know that is hard. If you don't have storage space, like, take pictures on your phone, like whatever you can do, because if you get sued 6 years after you moved out and you don't have any documents to show that there were bad conditions in your apartment, and that case goes to trial, it's going to be really hard to prove that you should get a rent abatement. Also, if they agree to waive all the arrears, keep any written agreements you had. If it was in an email, if it was in a text, whatever it was, take screenshots of them, save them somewhere safe, so that if you lose your phone, you won't lose them forever. Store them in the cloud. Keep pictures, receipts from 311 complaints, violations, whatever you got. Keep your rent receipts or your last rent bill showing how much you owed when you moved out, if the rent bill is correct. Take pictures showing what the apartment looks like when you moved out in case the landlord refuses to return your security deposit. And that is a real thing. Like, there are all these landlords now that people are moving out and they are getting sued for $10,000 because the landlord, there's a clause in the lease that says that before you move out, you have to return the apartment to its original condition. And the landlord is pretending that they had to do like $10,000 worth of repairs to get it back to its original condition. So that is a thing that is happening, and I don't want it to happen to any of you or your friends or family. So just take pictures before you leave. You do have a right to ask the landlord to do an inspection before you move out. And there are notice requirements that the landlord has to let you know within 2 weeks if they're not going to return your deposit and why. And if they don't, they give up the right to that deposit. But you know what? It's a lot easier to just have them sign off and say everything is good before you move out than have to fight with them in court about whether or not they met the deadlines and what the condition of the apartment was. And this is just a little deeper dive into things to look out for in stipulations. So this is the language I keep repeating this because I really want it to sink in, and it's not something people are exposed to a lot, so they're not as familiar. But if there's language, they typically use language that may mean that they can sue you later in a different court. So if they say rent arrears or use and occupancy are owed, but they don't say that they are waived, if it says that a lease is in effect, but not that you were released from the lease, that if it says the rent arrears are severed, and that the landlord reserves its right to sue you in a different forum, be especially concerned if it doesn't say that you reserve your defenses. Because if it says the landlord reserves their claims, but doesn't say you reserve your defenses, and you end up in court again, the court is going to say you gave up your right to bring up your defenses, even if you had really great ones, even if there was mold all over the apartment and a vacate order or whatever, the court may not want to hear anything about it. The other thing to look out for is if it says the case is discontinued without prejudice. It might say it's just discontinued without prejudice to certain things. So it might say it's discontinued without prejudice to the security deposit or to certain fees, or it might just say without prejudice without saying anything. And that means the case has not been resolved. There's no final determination on the claims. And in theory, either side could file a new case later on, though there are some time limits I'm not going to get into because it depends on a bunch of stuff. So talk to a lawyer if you have to. And you have a right to like just ask for language to be put in there. If you have an attorney, not all housing attorneys are really up on this and don't realize that resolving the housing court case only partially might end up with you being sued later, because as I said, that's something kind of new. It didn't used to really happen, and now it happens frequently. So you may have to kind of push your attorney a little bit about what happens. And the other thing is you have a right to have a judge go over it with you and to ask questions. And like I said, some of the judges are like, oh, it's fine, go ahead and sign it. But you have a right to ask questions, and you are your own best advocate. So be sure to do that. Like I said, a lot of them are operating on dated information. The fact New York State has laws that protect certain types of income from debt collection. It's usually different kinds of government benefits, child support, foster care payments, Social Security, those kinds of things, and public assistance. So if they look at you in that moment and maybe your income is protected from collection, they may make a decision that it's okay to not resolve these issues, because to sever a rent arrears for another time, because if they got a judgment against you right now, they wouldn't be able to use it to collect money from you. But the problem is a lot people's lives change, right? So you may be on public assistance now. That doesn't mean you'll be on public assistance 6 years from now. And so if you start working and suddenly they're going after you for like $10,000 in rent arrears, that's not a fun thing either. So I also am going to just throw this out is a lot of people are confused about the difference between different kinds of judgments. So possessory judgments are when a landlord gets the right to take back the apartment. They get possession of the apartment. Then there's a money judgment, and that's when the landlord gets the right to collect money from you. Once the landlord has a money judgment against you, whether they got it in housing court or if they sued you in another court, that judgment is what they can use to freeze your bank account or to garnish your wages, to have some money taken out of your check by the marshal every time. So also be aware that if you see something about a money judgment, like, and they tell you don't worry about it because like your income is exempt, if your income might change at some point in the future, that could be a problem. So exempt now doesn't mean exempt later. And these are some resources. These are mostly for civil court, to be honest. I don't really know of any resources for Supreme Court or, because other than just going to places that do those, legal services organizations can sometimes do Supreme Court cases. But for a civil court, Claro is a program. It's volunteers who give assistance to unrepresented defendants without lawyers who are sued in civil court, helps them identify defenses, fill out court forms, but they don't go to court with you, but they can help you navigate the court system, understand what you have to do, and they can help you fill out the paperwork. The volunteer lawyer for the day program is also volunteers, and they are available in civil court on certain days, and they will represent you for the day. So you have an attorney, but they don't do any work between court dates, and it's not guaranteed that they'll represent you the next time in court, but they can help you go to the judge and try to negotiate a settlement, or if you have an order to show cause to vacate a default judgment or something, they can talk to the judge about that and the other side and try to work that out. There are different ways to get access to that program. Most of them, if you show up in the courtroom and you go and say, hey, can you help me? They will try to, but they do have limits. So Manhattan has an online portal where you can request help. So I have that link there. And other boroughs, it tends to be there's like a sign-in sheet. NYPIRG is the only place I know of that really has a small claims project. And I think they're more focused on suing people on small claims, but they do have a lot of really helpful information about how small claims works. And there's a few legal services organizations that help with small claims occasionally, but not regularly. And just for general information, lawhelp.org/New York has listings of legal services organizations that can help defendants in courts that aren't civil court. Usually it's under the category of consumer cases or debt collection. So this is a lot of information to absorb. And I went through it pretty fast. There's even so much more, but I wanted to get you the basics. And the goal of this is really to just get you to recognize when something might be a problem and to encourage you to consult with advocates if you have that opportunity before you enter into any kind of agreements that might not resolve all your rent arrears completely, so that you know what you're getting into. And sometimes you have no choice and you just take the best deal you can get, but you need to know what to expect if the case might come back in the future. And now I'm happy to answer any questions if people have any.
Yes, we definitely have a lot of questions.
Okay.
So the first question actually goes back to the ADA accommodation part. They ask, what accommodations exist for persons learning disabilities, difficulty reading or writing?
So it's not so much what accommodations exist as what you need to help you participate in court, right? So if you're in a courtroom and you have difficulty reading because of, for whatever reason, a learning disability, low vision, whatever it can be, you can ask to have that agreement read to you out loud so you know what it is you're signing if it's something you need to sign. There aren't really any accommodations about before you go to court. Like if you get court papers, what do? You don't know what they are or what they say. So that's not so great. But all the courthouses have a legal resource center. Some of them, I think in Supreme Court, they call it the Office of the Self-Represented. And in other cases, it's called the Legal Resource Center, where you can go and meet with court personnel and they can talk to you about what the papers are. So that might be something. But it's going to depend on what you need to participate. So it can't, and it has to be court related. So it has to be when you're in court, what's going on. Like, then the other question is, like, say, I have a lot of clients who are functionally illiterate or completely illiterate, or maybe they are, English isn't their first language. So the court is great about interpreters. Like for less common languages, you may have to wait around a while. It can be bumpy, but the court gets that they have to provide interpretation to people. But there isn't any kind of sense that they have to help people physically write stuff or physically read stuff. And that is a real service gap. Like no one really does that. And would the court consider that a reasonable accommodation? I think during the court date, yeah, if there's a stipulation and you need someone to read it to you, I think, yeah, they do that. But when it's something you have to prepare outside of court, like that, they're not going to provide you help for that, except these legal resource centers might be able to. And Clara will write stuff up for people. I help supervise the volunteer attorneys. Like I'm one of the people that helps do that. And so, if we have someone that has issues with reading or writing, whether it's a learning disability or any other reason, we write everything up and read it to them. So you might be able to get some help through those programs, but it would be harder to get an accommodation for that.
So just to follow up with that question, if someone is denied an accommodation and they appeal that request, does that put the case on hold?
Not necessarily. So that's why I said if you're if it's denied, you need to ask to adjourn the case, and then you need to tell the judge that's why you need the adjournment, because you requested an accommodation, you need the accommodation to be able to participate. And so you need the adjournment while that is pending. And I think most judges, if you are filing or shortly going to file an appeal, they get that. That's a legal concept, so they understand that. So they should adjourn it for you during that time. I don't know how long it takes, to be honest. I've never appealed one of these through the court process. So I'm not sure how long you need, but a lot of courts will adjourn things for a month or two if you have an appeal pending. So it should put a hold on the case in theory. But you
The
have
next-
judges that are like bad and they're like, why can't you just do it? You're here, so I'm not saying you won't get hassled, but like stick to your guns and say it's your right to appeal, and that should do it, hopefully.
Definitely. The next question we have are clauses in leases that waive the right to a trial judge or force arbitration enforceable?
So clauses that waive your right to a trial? Is that what you
To a
said?
trial judge,
To a trial judge?
or they force them to go to arbitration. Are those clauses enforceable?
So a trial, yeah, you can't waive your right to a trial. And arbitration clauses are a little different. So I haven't actually seen that in a housing context, but I think it would be very hard to enforce that clause, but I have no direct experience with it, so I don't really know. I know they're really common in credit card cases, and I get my clients out of them a lot. so I know you can overcome them for that. So I imagine you could in housing court, but I think if you're a rent stabilized tenant, you can't waive your rights by signing a lease that has clauses that violate the rent stabilization law. And though the rent stabilization law doesn't specifically say every tenant has the right to a trial by judge, it's kind of implied. So I think you'd be okay. But on the other hand, you can waive, if you sign a lease that says you have no right to a jury, that's a waiver that the courts will respect and enforce. Sorry, I can't be more certain.
Somebody asked, but they can keep the security deposit if you break the lease early, correct?
So technically, the parties can agree that the security deposit will be applied to the last month's rent, but they don't have to agree to that. So the landlord can say, no, I don't want that. What if you trash up the apartment and then I don't have the security to apply to pay for that because you applied it to the rent? So you can't assume. Most landlords will do that automatically. It's usually not an issue, but I'm just saying it's supposed to be by agreement. It's not supposed to just be like you leave and make that assumption. It doesn't mean the landlord will agree to do that.
Next question is, what qualifies as a good faith effort to re-rent the unit? And there's a second part, and there's a price factor, right?
So it's still being the law that changed that. And before June 2019, landlords didn't even have to try. They could just let the apartment sit there and not even try to rent it and still sue you for the rent arrears. So in 2019, a law was passed that changed that. And so it doesn't really define in the law what a good faith effort is. And there haven't been a huge number of cases. But generally, the way the courts seem to be looking at it is they have to try to rent it. Like they have to actually post it. They have to make a good faith effort. If they're renting it, they look at whether the reason they couldn't get a tenant was maybe because of the rent that they posted it at and whether that rent was justified. So I think I gave the example of they negotiated a preferential rent with someone. It was $1,000. That was the going rate. And now the person's posting it for the legal rent, which is maybe like $3,000, but they can't get any takers. Like, is that really good faith? Because you couldn't get it before. And maybe now it's the pandemic. It's even harder. And you're posting it for a higher amount, like that much higher. like maybe the court wants to look at that. So some courts have looked at that, but it's not just about that. There's a lot of things people could bring up, but like I said, I haven't really had any cases where this came up, but it might be the condition of the apartment. Like maybe it was in terrible condition and that's why the person moved out and the landlord didn't really fix it up. So nobody wants to rent it because it's still kind of not in good condition, or it has lead paint, or it has mold. So they want to look at the circumstances of why the landlord couldn't rent it, and if the landlord had it in their power or control to change those circumstances to make it easier to rent. And they'll look and see if the landlord agreed to lower the rent or not. And if they like made some concessions, they're more likely to find good faith. And if the landlord said, no, this is the amount I want, take it or leave it. And another thing I should also say is sometimes landlords lie and they say that they didn't re-rent it when they did and it was occupied. So if you were friendly with any of your neighbors, like make sure if you break a lease that you maybe keep in touch with them so you know if the apartment was relet or not and when.
So can they sue for attorney fees outside of housing court? And the second part to this and if so, would this include time billed in housing court?
So that is a complicated question, which is why I didn't put it on the slide, because you really need to talk to someone about the specific cases. But generally speaking, if you, if a landlord sues you and wins the case, they can ask for attorney's fees. And then the judge has to decide if they should really get them or not. There are things they look at, like first the lease has to say they can get them. The lease doesn't say that, they can't get them. And even if they did, they look to see who's they call it the prevailing party. So if the landlord maybe got some rent, but not all the rent they asked for because there was a rent abatement or something, they have to decide if one side really won the case or not. And if nobody really won, like everybody got something or everybody didn't get something, the judge might not award attorney's fees. But to get back to your question, if you get attorney's fees, you have to apply to get them in housing court, because that is the judge who's going to decide if the parties won the case. So a lot of landlords, and I don't know why, if they're just trying to avoid a judge or something, but some landlords start a new case in another court for the attorney's fees from a housing court case. And generally you can get those cases dismissed because it's improper and they should have gone back to the original court, because that court had the power and the authority to issue those attorney's fees. And there was a second part, I think, or not.
So the second part was, and if they are able to, basically, if they are able to sue for attorney fees outside of housing court, would this include time billed in housing court?
Right. So no, if it's a housing court case, they should be asking the housing court judge for an award of attorney's fees. So they shouldn't be suing somewhere else. Like I said, sometimes they'll start a new case in civil court for maybe, and sometimes this is just, maybe you owed $500 and you set that aside. They don't want to sue you for $500 in civil court. So they add on what they think they should have gotten in attorney's fees from housing court. And in that case, that brings it up to an amount that they feel it's worthwhile, but they shouldn't be doing that. However, there are things called legal fees that are not attorney's fees that the lease might say you owe. So it might be like the cost of filing the case in the housing court or whatever, or it might be the cost of issuing them writing up a non-pay petition, and then maybe you pay before it gets, you get the rent demand and you pay up, so the case never really gets any time in housing court, but it's filed. Like those types of fees, they probably could get in a later case, because if your lease says that, they can sue for that in another case.
So the next question it's not a question, it's more of a comment, but I'd imagine that if you have a preferential rent, landlords would be eager to let you go early so they can charge the next tenant the legal rent. I don't know if you have any comments on that.
It kind of depends on what's happening in the housing market at the time. Like sometimes the preferential rent might be more than they could get. You have to assume that the market doesn't always favor the landlord. So, but it just depends. Like some landlords, they don't want to, they have a tenant that's paying, they don't want that tenant to go and then have to risk having somebody move in and not pay. So even if they think they could get more money potentially. So, but yeah, I think generally like it's more incentive for them to say, sure, if you want to break your lease and give up your tenancy, it's more likely they'll accept it if they think they can get more money if you leave for whatever reason, whether it's preferential rent or they can get a rent increase because they do some individual apartment improvements, even though they can't up the rent as much as they used to before some changes in the law, at least as far as rent stabilized tenancies go.
Right, rent stabilized tenancies. Now the increases are from the preferential. There may be some differences if it's a new tenant, but yeah, just for that, just to let people know. And then another comment, if you break the lease early, I was under the impression that the landlord wasn't required to return the security deposit. I think you already addressed that, correct?
Yeah, I mean, they can give it back to you, but they have to. Okay, so basically what I think the law in this area has been evolving a little bit, and I didn't research it before this, so take what I'm saying with a grain of salt. But in principle, if the landlord's not going to return your security deposit, they have to say why, and they have to notify you. If they don't do that, they have to give you back your security deposit. So if they want to apply it to your rent and your lease says that they can do it and you sign something, you sign the lease and the lease says, if you move out early, the landlord is free to take the security deposit and apply it to your rent. Like the landlord can do that. If the lease doesn't say that and you didn't agree to it, you might be able to get into a fight about it and whether the landlord could do that or not. But if you still owe money to the landlord, then the landlord's going to come after you. So maybe if they have this security deposit, they won't. So it's up to you. You're going to have to figure out if you want to risk that or not.
What if the landlord damaged your apartment with demolition, construction work, and adjacent apartment, causing holes, cracks, floor wall separation, removing insulation, resulting in pollution, lots of smoke, cigarette, opiates, cold air, dust to you? You cannot use your apartment as you wish.
So yeah, that sounds like that could potentially be constructive eviction. It can also be a partial constructive eviction, which doesn't. So if it's completely uninhabitable, like that sounds bad. I don't know if it's bad enough that you, because construction can take place during certain hours. So it might be like it's just bad certain hours and the rest of the time it's okay. But if it's that bad and it's like 24 hours and they're not complying with the city's requirements to control dust and other particulates caused by construction and so on, you might be able to argue that you were constructively evicted and so you shouldn't have to pay rent. But that means you have to leave the apartment. You can't argue that you were constructively evicted and the apartment is uninhabitable if you're still in the apartment. There is something else called partial constructive eviction, and that's when you can't use certain areas of the apartment, but you can still kind of live like in your one corner that isn't impacted by the horrible stuff happening. It happens a lot, like if the ceiling falls in one room, but the other rooms are still okay, but you can't use that one room. And in that case, they kind of prorate the rent. A court would, they'd look and see like, okay, you could use 75% of the apartment. So you get a 25% rent abatement or whatever. So it's really fact specific and you need to really do a great job of documenting it. So if that were a situation and I were advising a tenant, I would be like, or if it were me, I would be calling 311. I would be calling the Department of Buildings. I would be taking pictures. I would be calling my elected official. I would be taking pictures. I would be doing everything to show how bad it was in my apartment before I tried to argue that like I shouldn't have to pay. And some people, you're under so much stress and you have a baby or something and you're worried about lead paint, and you're not going to hesitate. You're going to leave. Your baby comes first, right? So, but get your baby out and go back and take all the pictures and make the complaints and make sure they can get into the apartment if they come to inspect. That would be my suggestion, just practically speaking.
In cases where someone passed away but owed rent arrears at the time of their death, could their estate be sued?
So that's really a trust in estates question. But yeah, if they had an estate, their estate could be sued. Like if someone passes away and they're in housing court at the time, like the case would have to be switched to make the case be against the estate. And then, so if you're already in housing court, and if the person passes and they owe money at the time they pass and there is no pending housing court case, yeah, they could sue the estate. But the estate has to be somebody, right? Like a lot of people die without a will, and there is no estate to sue. And you have to have someone that's named in a will to be your executor, or somebody has to go to surrogates court and get, they're called, I think, letters of administration to be the representative of the estate. So there might not even be anybody to sue. It's more of an issue if the person leaves someone in the apartment, if it's rent stabilized and they have succession rights. There's also the issue of like, would the person with succession rights be responsible for that money, those rent arrears, if they didn't have a lease in their name at the time? And generally the answer to that would be no. So they would have to go after the estate.
What options, both in and outside of housing court, for such apartment damages that you are forced to spend more time away, inhabitable during nights and weekends, and landlord just ignores repeated requests for repairs, or if there were substantial repair cost?
So if you want money, like if you just want the repairs done, you can file an HP action in housing court. But if you want money, you have to sue in either small claims, civil, or supreme, depending on the amount you want. So small claims is easiest. You can only get up to $10,000. If you think you deserve more, then you would up, if it's $50,000 you think you deserve, or then you sue in civil court. Small claims is easier though for that kind of case, generally, I would say. But I did get some money for a client in civil, so you can do it in civil, but it's harder to do without an attorney.
What can be done in event that landlord's attorney uses threat of plenary action, including attorney's fees, to run the table on the stipulation? As example, using a time is of the essence clause where tenant is required to waive all opportunity for order to show clause upfront.
So everybody's case is different, right? And sometimes you have really strong defenses that you can use against the landlord, and you can kind of play a game of chicken and say, let's take that to trial, because like, no, I'm not going to do this. And sometimes you're not in a great position and you owe the money and you have no defenses. And then you're just going to have to get the best deal you think you can at the time. But if you can make things more difficult, that makes it, if you can raise things, like if you weren't served with the papers properly, you can ask for a hearing on that. That's going to cost them a few $1,000s. So maybe they're going to give up that clause if it's going to cost them more to get it. Or you can say, if I'm giving you that, then what are you going to give me? Like, give me, if you're moving out, you want more time to move out, or if you want more time to pay the arrears, or you want the repairs done faster or something. But it's not, unfortunately, really something I can tell you. You just have to look for your strengths. Like if you can go to an elected official, because you can organize the building, because everyone, if there are things you can do to put pressure on the landlord, do those things. And then you will have a way of, more of a bargaining chip when you're negotiating. Like if you file a complaint with DHCR for reduction in rent or something, you can say you'll withdraw that request if they'll give you whatever you want, so which you can do. So you just have to look for an advantage that you have that you can use as a bargaining chip to avoid that language if you can. And sometimes you can't, to be honest.
Mhm. So we only have a couple or more minutes. Two people are legally married, but only one name is on the lease. The person whose name is not on the lease moves out, no divorce. Is the person who moved out responsible for the rent still legally married?
If your name is not on the lease, you are not legally responsible for the rent if you are married. You have a right, if it's rent stabilized, you have a right to be on the lease if you're married, if you guys both want to be on the lease. But if somebody who's not on the lease moves out and they never signed a lease, they're done. Like the landlord can't go after them. If their name is on the lease, yes, the landlord could sue them even if they moved out.
But the person they were living with, that person, like the roommate, can come after them in civil court.
Oh, for the roommate? Yeah, the roommate could if they had an agreement, and if you were if you weren't paying your share of the rent, and you had and you're a roommate, your roommate can come after if you have an agreement. But if it's not in writing, they would have maybe some difficulty in proving it, but they could.
The renovations, I think it was already answered, but I'll ask. The renovations took place in 2020. The damaged condition still exists. Tenant cannot leave or will be homeless. Can tenant get repairs done, force landlord to pay, and where would this take place?
So getting repairs, probably your bet is filing an HV action to get an order for the landlord to do repairs, and for damages that you experienced, money you had to pay out, either just replace stuff or stay somewhere else on days when you couldn't stay in the apartment. Like that would be small claims or civil court, depending on how much you're suing for. Civil court is always about money, and small claims, they're all about the money.
And one last question. Does this advice change dramatically for holdover matters?
Not so much. It's similar. I mean, it's in holdovers, you're talking about use and occupancy instead of rent. And use and occupancy is a little more of a slippery concept because it might be more or less than the amount in your lease. Like usually it's people agree it's the amount in the lease, but you can argue that the apartment is in bad shape, so you should pay less. But the principles are all the same. They can still sue you, and if you don't resolve anything in housing court and there's use and occupancy claims and they're not resolved, they can sue you in another case. I will also say, like, one of the reasons you need to talk to an attorney is sometimes if people don't raise issues that they could raise in the housing court case, they may not be able to raise them in a later case. Even if they weren't part of the housing court case. But that's complicated, and you need to talk to an attorney to see if that applies to your individual circumstances.
And I think I'll just double check. That was the last question.
Can I just riff a little more on the last question?
Sure.
So the holdover stuff can be really complicated too. If it's a non-primary residence holdover, and then there's somebody left in the apartment who's a successor tenant, and then like the landlord won't take rent from them because the lease isn't in their name and won't recognize them as a successor tenant. That can all get like super, super complicated. And a lot of times the successor tenant wouldn't have to pay, but not always. So that's another case where you really need to talk to an attorney.
Okay, I don't think we have any other questions, but I definitely wanted to thank Miss Mary McCoon for this training. It was very helpful. We got some great commentary stating that this was a very helpful training. Hopefully it will be helpful in people's day-to-day lives, but definitely thank you so much for this, and have a good day to everyone.
Okay, great. And I put on the front of the PowerPoint, it has the intake line for my office. But I'm the only one in my office that does the civil court cases, so be merciful. We're understanding if you can't get an appointment, but lawhelp.org is another good resource. Okay, and thank you guys for all your great questions and for the opportunity to present. It's a really important issue.
Definitely. And again, this PowerPoint will be on our website. We've posted the information on the chat, and we also have a great training tomorrow. So feel free to check it out. It's MCI's. So yeah, definitely feel free to check it out. But again, thank you, Ms. McCoon, and everybody have a wonderful day.
Bye. Thank you, Ms. McCoon. We'll be in touch.
Thanks.